Okay, ladies and gentlemen, welcome. Thank you for coming today. We are very excited for this panel. It's a very timely topic, but before I turn things over to our moderator and to get into the meat of this, I want to just do a brief welcome. My name is Wes Rist. For those of you whom I have not met before, I'm the Director of Education and Research here at ASIL. For those of you unfamiliar with the American Society of International Law, we are a 108-year-old membership association. We are nonprofit, non-advocacy, nonpartisan, so we provide information and education resources to a wide variety of constituents, including the legal community, judicial education, all the way from high school teachers up to practicing international lawyers and judges around the world. We have a very active membership that includes over 100 representatives from over 100 different countries. In fact, 40% of our membership is from outside of the United States. And we have a very active interest group program, which are interest groups that focus on specific topics and subject areas and demographics. Today's event is actually sponsored by two of our interest groups. One is the International Law and Technology Interest Group, and the other is our New Professionals Interest Group. We actually have both of our co-chairs for our New Professionals Interest Group here, so we're very excited about that, having Lisa Bruner and Kathleen Clausen here. So today's event, we're excited to have this discussion, and we do have a hard time limit for one of our speakers who has to leave to make another event. So I'm going to turn things over right away to our moderator and leave him to do introductions and set the tone and go from there. Paul?
Great. Thank you. So I'm Paul Berman, and I am a professor at the law school at the George Washington University. In some ways, this is sort of back to the future for me because I started as a law professor in 1998 doing internet law and wrote one of the first law casebooks on internet legal issues, cyber law, whatever you want to call it. And I remember discussions then about, whether internet search engines or internet service providers should be counted as common carriers and what regulations would flow from that and so forth, and plus all the jurisdictional conundrums with regard to who gets to regulate various internet activity. And in some ways, the discussion we're going to have today is just the next iteration of both of those kinds of issues. So I'm also one of the co-chairs of the International Law and Technology Interest Group of the American Society of International Law, and I'm very pleased to welcome you on behalf of the interest group as well. And we have an audience both here and presumably on the internet. So our panel today, and this is going to be less about sort of formal papers and more discussion oriented. But our panel is, first of all, Meg Ambrose, who's an assistant professor in Georgetown's Communication, Culture, and Technology Department. And then next to her, we have Arturo Carrillo, who is a clinical professor of law and director of the International Human Rights Clinic at the George Washington University Law School, and one of my colleagues. And then we have Ross LaJeunesse, who's head of international policy at Google. And since we are going to be talking about a case involving Google, it's always good to have someone right on the front lines of figuring out how to respond to the case, interpret the case, and implement some of the rules and so forth. So we'll be able to both understand this very, very interesting European decision and talk about some of the implications of it from both a privacy, human rights, and free speech perspective, and see what's to come and how this will impact both business operations and governments on into the future. So on the assumption that although there was a lot of news accounts about this decision involving Google in Europe, my assumption is that either people are a little foggy about it. Frankly, a lot of the news reports, even at the time, I think were imprecise at what the extent and scope of the opinion actually was. People talked about sort of a right to be forgotten, but they said it in very, very broad terms, which were actually broader than what the court said, and so forth. So it seems to me that it would be useful, at least in the first instance, to just summarize what the issue was in the case, what this idea of a right to be forgotten is, and what the European Court actually ruled. And so we're going to start with Meg, and then we'll sort of have a little bit of introductory conversation. I'll ask some questions. I'll try to get some discussion and debate going, and then we'll open it up to the floor. Go ahead, Meg.
So the digital right to be forgotten, this new version of a right to be forgotten, means a few different things. The number of different ideas that have sort of converged under this title, the right to be forgotten, which is flashy and unfortunate sometimes. One iteration of that was put through the court system in Europe, the Spanish version, and I'll talk a little bit about that. But at the core of all of these ideas is that individuals should not be shackled to their past by personal information. That takes on a number of different forms and a number of different implementations, but the European Court of Justice was answering some questions that rose up from the Spanish Data Protection Agency's decision regarding Google and its refusal to remove to disassociate some individuals from some content that came up when you search their name in the search engine. So there were about, I think, 90-ish requests that the agency had determined. Citizens had come to them and said, we think that this should be forgotten. The agency agreed with them on these. In regards to Google, Google appealed 5 of them, and the Spanish court system punted it all the way to the European Union Court of Justice. So that was the case that came down that just changed everything, but it was extra surprising because the Advocate General, the initial opinion was what most people expected. I'll leave it at that. And then and these are usually relied on. And so the European Union Court of Justice did not take any of it into account, seemingly, and went a different direction. And what they determined was that under the 95 directive, which is being replaced by regulation in the next few years, and we can talk about the difference between those two, but this is an interpretation of a very old directive, that under that directive, Google was a data controller, which meant that it had to adhere to all of these things. Its search activities had to adhere to all of these things under the directive, including Article 12, which is a right to access article. It includes a right to rectify and erase, but we all thought for like 15 years, only under certain circumstances. And Article 14, which is a right to object, which again, we're really under the impression that this required a lot of other things to be in place. The European Court of Justice did not agree, and there is a lot of the opinion that reads like one version of the right to be forgotten, which is really about identity and reputation and a search engine society, but it's all interpreted through this 95 directive, which really, as you read the directive itself, it reads like it's about cookies. You know, it's about privately held collected data, and so we have these two ideas that are converging, and it makes it for a very confusing read, and I do not blame these reporters for confusing everyone.
So let me just follow up on that, just to be clear. In none of the versions, including what the court said, as I understand it, maybe correct me if I'm wrong, is it sort of a blanket right for an individual who just doesn't like the stuff that pops up from a search on their name to ask Google or ask any search engine company to remove that, right? So it's not like a blanket, I don't like the fact that this information is out there and this search engine gives these results, right? So there's some limitation on what is within the scope of what Google can be asked to do. Am I correct?
This is one of my favorite parts of the case. So it doesn't actually have to be something bad. I can object, and an artist recently objected to wonderful reviews of his past work to try to have a Streisand effect for his new project, and it totally worked. It doesn't have to be anything bad, which is a weird part of the opinion. They say you just have to object, but the scope of that is limited by whether the information can be retained for any of the exceptions. So there are these exceptions to that, and the court offers very little substantive guidance on how to balance any of those. So yes, there are exceptions, just no one knows what they are exactly or how to apply them.
Okay, and we'll get to more how Google is interpreting and applying it in just a minute. Arturo, maybe you could talk a little bit about what you see as kind of the comparative human rights aspects of the case sort of on both sides and how they weigh and cash out from your perspective.
Sure. Thank you very much for the opportunity to be here. Yeah, I am very much interested in the human rights perspective in reading this case, and it's interesting. There was a press release at the time that the decision came down that broadcasted the following heading: "An internet search engine is responsible for the processing that it carries out of personal data which appear on web pages published by third parties." I think a more accurate heading for that press release might have been "Internet search engine deemed to run afoul of new judicially fashioned human right in Europe, the right to be forgotten." That would probably be a more accurate description of what happened in that case. And let's be clear that this right did not exist in Europe before this decision. The Advocate General was pretty clear about that in his decision from the prior year. And of course advocated against the creation of such a right and all the practical difficulties that it would entail. So how did then the court, the European Court of Justice, reach this decision, and how did it balance these rights? Right, on the one hand, right to privacy and protection of data of the data subject, and on the other, freedom of expression and information, among others. The straightforward answer is that it tipped the scales in favor of the former and at the expense of the latter. And so how do we know that it did this? Well, when you read the decision carefully, you see that it constantly refers to the fundamental rights of the data subject, right? Fundamental right to privacy, fundamental right to data protection, referring always to the directive. And then when it talks about the countervailing rights, it refers to them as interests, the legitimate interest of users, the interest of the public, the general public. Now, to be fair, that is the terminology in the directive, right? But it's an old directive, and it did not contemplate this kind of scenario by a long shot. And it's frankly disingenuous not to refer to the fundamental right to freedom of expression or information, or the right to conduct business, which is Article 16 of the Charter, right, on European Union fundamental rights. So it was loading the deck from the get-go in this discussion. And when you put fundamental rights on one side of the scale and you put interests on the other, it's obviously going to fall in favor of the former. And that's pretty much what happened here. So, I think I'll leave it at that. Just conclude by saying it was quite a revolutionary decision with a lot of impact.
So, but just to play devil's advocate for a minute.
Mm-hmm.
So when you say, there were only interests on the other side, and the interests sort of were given short shrift, the interest of users in getting information, the interest in the public to get sort of important data and so forth. If there are a series of exceptions where certain things can't be removed, isn't one of the things that can't be removed, even under this decision, certain information that's on websites about, for example, public figures, and therefore people about whom the public would have a particular interest in getting information, and that was left alone, right? That's not within the scope.
Well, it was a very vague and open-ended standard that did give the appearance of balancing in that, for instance, it allows the operator to determine at the request of the data subject, if the information that's being requested to be taken down is inadequate, irrelevant, or no longer relevant. Right? What that means, we're still trying to figure out. And it does say that the importance of the information to the subject, as well as the nature of that information, if the person is a politician and there's a great or heightened public interest, then that would presumably tip the balance. But in the end, that's something that Google is going to have to decide, or the operator is going to have to decide. And so, it's just a very amorphous standard, and it doesn't really do justice to the true balancing of rights that was required here, and that the Advocate General did much more expressly and effectively.
Okay, so Ross, why don't you tell us a little bit about your or Google's point of view on the case, and also what it will or may mean for the future for your business.
Sure, happy to do it. Thanks for having me. We don't like the decision, obviously, to state the obvious. We think it's a bad decision. We were surprised by the decision, looking at the Advocate General's writing, and we had expected the court to take that into account much more than it did. We think it's problematic for some of the reasons that Arturo and Meg highlighted, but I'll restate them. The first is that we feel like the court got the balance wrong between the privacy rights of an individual and the rights of society to express themselves and to know history. Another reason we have issues with this ruling is that it puts Google in the position of making decisions about balancing these rights, and that's not a position that we want to be in as a private company. It also provides very little guidance about how to go about doing that. As Meg mentioned, the ruling is very vague. It talks about, that the removal of information should happen if it's inadequate, irrelevant, no longer relevant, or excessive in relation to the purposes for which they were processed, the data was processed. Very little other guidance on how to do that. So we find ourselves in a position of trying to comply with this ruling, not liking it, but trying to comply with the ruling. And it's been difficult. We've had over 100,000 requests so far. Each one of them has to be individually read and analyzed and acted upon. It's very difficult to develop some sort of overarching guidelines because it's so factually driven. Example, you have a former public official who makes a request. Okay, you would look at what position that individual was in, what information does he or she want to have taken down, does that individual plan on running for office again, at what level was he or she serving, what level is he or she seeking office for the future, what's the nature of the information. There is this public interest, there is this sort of exception, this one little carve out, but again, very vaguely defined.
Now, prior to this decision, did Google never receive requests to remove search results and have to evaluate those?
So we've always received those requests, but our approach is that as a search engine, and for some people as a means of accessing the internet itself, we very rarely took action on those requests. There are very limited circumstances in which we would take these links down. It's also important to remember that for some people there is this conflation with Google and the internet itself, and that's really not the case. What we're required to do is remove the links upon an individual's request. That does not take that information down from the internet itself, right?
It's true, but that's a little bit disingenuous because if nobody can find it...
That's not disingenuous when you're talking about the New York Times website or the Wall Street Journal website or any number of sites which receive an incredible amount of traffic. So it's not disingenuous. And it's important to remember because for many people, they think Google is the internet. And I say that because the response to a lot of these requests in the past has been to listen to them and then say the best way of doing that is to go to the underlying material itself, and if it's taken down, we're constantly refreshing our results and it'll be removed from the index. So there, cases in the past would be child abuse imagery, which is universally illegal. and agreed upon, has no place online, and when required to do so by a valid and very specific legal court order.
Okay, so but it's not dissimilar in certain ways from the idea that you might, if you objected to certain content, as people have in the past, you might go after the internet service provider rather than the person who uploaded the content, because the internet service provider, or in this case Google, the search engine, is easier to find, easier to figure out who you're litigating against and where and so forth. So it's not surprising in that sense that people might prefer to go to the search engine rather than to each individual website.
Oh, I agree with that absolutely, and I didn't mean to sort of dismiss your point, out of hand, because it is true that if you take a link down, it is harder for people to find. In some cases, very much harder. But I really want us to keep in mind that Google, this conflation does not help us really understand what's going on and the dynamics at play here.
So so what's the state of play? So you've got all of these requests. You have created some unit within your general counsel's office that's looking at these requests? We
have a bunch of lawyers and a bunch of engineers trying to make their way through these requests right now, and as you can imagine, it's not easy. There aren't any, we don't have a set of precedent here to say, oh, that's an easy one, because it is so fact-driven. A couple other things to keep in mind is that the right of appeal for these requests is one-sided. If the requester doesn't like the decision we've made, he or she can appeal that to the relevant data protection authority in his or her jurisdiction. The publisher of the content has no right of appeal. So if we take down information, a link to someone's information, the website owner or publisher does not have a right of appeal. So it's
and why is that? Why couldn't the website owner say that you were inappropriately blocking access to their website?
It's not in the ruling, and there's no right for that individual to do it. And in fact, we've interpreted parts of the ruling to say that there are limitations on our ability to even provide that information to users and to the publishers, and we've gone about doing that. The other thing to keep in mind is, as complicated as each of these cases is, we need to multiply it by 28, because there are 28 individual DPA authorities. Even though this is a ruling for the EU, each data protection authority has jurisdiction over that jurisdiction, so we can look at multiplying the individual factors by 28, because the DPA in France might react differently than the DPA in Germany to a specific case or request.
So what about, is there any likelihood that there could be a regime kind of similar to what eventually was agreed upon, at least in the United States, with regard to copyright violations, where there's sort of now a notice and takedown provision, and a whole regime where you sort of get, for those who don't know, you get a notification as a website that you're linking to copyrighted material or something like that. You take it down, you issue a notice. The person who created the material can then object or to whether it's a copyright violation and so forth, and there's a whole protocol for that. Is there any possibility of that kind of a system evolving, and if so, would that help?
Well, one of the things that we're doing is trying to not only comply with the ruling, but understand the broader implications of the ruling. So we have put together, it's called an advisory council, and some people get confused because they think the advisory council is actually, reviewing and overriding decisions that we're making about specific requests. But actually, the role of the advisory council is to help Google and society and our users figure out the implications of this and how best to move forward. So we have, Frank LaRue, who until recently was the UN Special Rapporteur on Free Expression. We have Jimmy Wales. We have Eric Schmidt and David Drummond from Google, former DPAs themselves, serving on this council to help us chart a way forward. And it's very early days. We've had 2 meetings. We have meetings until I think end of the fall. We had our first 2 public meetings last week, one in Madrid, and I can't remember where the second was from. Thank you very much. So it's early days in figuring out the path forward.
Now, Meg, you mentioned the data protection regulation that is sort of still to come in Europe in your original remarks. Do you have a sense of how that's going to play out?
So the data protection regulation, which is intended to unify in some ways the directive that allowed for all of these countries to come up with their own laws within their own legal cultures, which is why there are 28 different rights to be forgotten that Google has to figure out based on 0 precedents. The regulation is intended to sort of harmonize that, but one of the things that it explicitly did was introduce a right to be forgotten, and at the time, that is how the European Commission was talking about it, that they were making this up, which is, again, why this case was so confusing that it came out this way, because they kept telling us that one didn't exist. So the regulation does nothing more than this. It has explicit exceptions. It doesn't offer any more balance. It's basically exactly what this case says, but in its own explicit section.
So it doesn't provide any further guidance beyond.
No, it is, however, our only hope. Google needs to do something. Like, it's our only hope that this will be resolved. I'm a pro right to be forgotten, actually. I think it's great. I think every legal culture should figure out privacy and expression and history within their own cultures.
So to unpack that for a minute. So
I would be
where do you think, so how would you define a good right to be forgotten? Like, what should it encompass?
It should encompass whatever the national legal system, however that balance is done in that country is how it should be done. Google should do what it's always done, which is adhere to whatever court orders it receives. It does this now. You guys answer, you take down defamation requests.
So then what's wrong with this decision? Isn't that an example
Nope.
of that?
Google has nothing to go off of. It's the agency. So citizens are going directly to them, just like they would with copyright, but with no fair use precedents. We already know that 1/3 of copyright takedowns are either fraudulent or mistaken. There's a legitimate copyright infringement question in 1/3 of all takedown requests. Every single request that Google gets is a legitimate right to be forgotten request. 100% of them. And so Google is sitting in this very awkward, I mean, I love Google, but I didn't really think I was going to be saying poor Google anytime soon. But this decision, it was like, what do you do with this? And the implementation is just, it's set up so nicely. All of these agencies exist. It makes so much sense for the users to go to the agency, for the agency to send these things through to Google, and for Google to either adhere to them, challenge them through the courts, just like they do with every other information policy that exists.
So it sounds like your objection is more to the process than
Yes.
it is to the content of a right to be forgotten.
Right.
So,
I loved it conceptually. I even think it works in America in very specific instances with children. We've seen this in California. There are some really interesting scenarios that people have come up with that Americans are pretty sensitive to. That is very narrow. Of course it would be.
so if someone had to bring it to a court over a common law process develops a set of principles for when takedown is appropriate, then you think if Google were then subject to that, that would be okay, and that would be more workable than this.
Google, from what I understand, Google always adheres to a legitimate court order to remove things. I mean, Google's biggest problem is that it's a link right now, that it is a perfect solution because the information exists still, but it's harder to find. And so that's the unfortunate technical reality for Google.
So Ross, why don't we clarify with you, do you take the same position as Meg that the idea of a right to be forgotten is fine, it's just sort of the way it's now being implemented is so difficult for you, whereas if it were done through a more kind of common law court process, that would be somehow better?
Yeah, no, I think that there are very legitimate questions which are currently being debated right now about an individual's right to privacy and what privacy means in this world with the internet, which are new and need to be debated and should be debated among policymakers and users and the entire internet community. The right to be forgotten strikes me as an incorrect way of going about achieving this. But you're right in saying that a large focus of our concerns right now is about also how this is supposed to be implemented and the role that it puts us in. We do comply with valid legal court orders, as you were saying, but this puts us in the position of having to make these determinations ourselves, which is not our role, and again asks us to do that with no guidance.
And Arturo, so you indicated some concern that this decision kind of tipped the balance way too far towards a right of privacy. Do you see any place for a right to be forgotten in your sense of kind of the human rights pantheon of rights-based claims?
Yes, I think there's an appropriate place. I mean, the right to be forgotten is a derivative of the right to privacy, and it does flow from how countries and cultures interpret that. I mean, it's true that I think you have to recognize that. And there are traditions, legal and others, that come into play in how you interpret privacy and the derivative right to be forgotten. My own view is that the balance here was struck unevenly vis-a-vis fundamental right to freedom of expression and information. I think the court had before it some positions from interested states that right to be forgotten should be limited to information that is illegitimate or unlawful, for example, which seems to me a better balance because you do have, you have to understand the implications of what this decision does in terms of the open-ended criteria for removal that it sets up. So now you have a private entity essentially censoring lawful content on the net. And struggling to do it in a responsible way. That just shouldn't be the role here.
But why don't I turn around Ross's argument going the other direction, which is it's not removing it from the internet. It's just saying that Google shouldn't link to it. And so from a freedom of expression point of view, it's the website still exists, whatever website it might be that has the information. The public can get that information. It's just we don't want Google or maybe any search engine above a certain size or whatever linking to it. Well, does that change the freedom of expression side of it any?
Well, yeah, I mean, the freedom of expression includes the right to impart and access information, and clearly both of those functions are impeded, when you don't have the search engine. But it seems to me that that information is available. It can be found. I don't know that is an impact that would change the balance as I've suggested. I think you have, because if you do a sort of consequentialist analysis, I mean, you have an entire universe of public individuals who they presumably want to access this information. What if Mr. Corteja decides to run, for instance, for comptroller or treasurer of this municipality after he removes this information? You can't get the fact that he had this attachment before, and that seems to be striking the balance wrong, because that's lawful, legitimate information that could eventually be of great relevance. So yes, I think it is an important consideration, but I don't think it changes or should change the balance of the fundamental rights.
And the last question to the panel before I open it up to the audience here. What do you see, any of you, as kind of the long-term consequences internationally of this decision? Is there any indication that other countries are going to follow and be influenced by this decision and adopt similar sorts of provisions, and do we see this spreading? Where do we see the trends going? Anyone have a sense of that?
So most of the world has European-based privacy laws, and we have seen, right after the decision came out, we saw a bunch of countries that were talking about, should we do this? India had a really, they sort of found the right to be forgotten in a similar article that they had within their own regulations really quickly. Whether they put this into practice, that was just an ongoing conversation. But I think most countries that have European-based privacy regulations, which is most countries around the world, are having this conversation. I hope that what we realize is that this is not a universal right, that this is not something we're going to find to be a universal balance, that there are important differences between cultures and what we forgive and what is important and what we allow people to move on from, what we consider reinvention is very different, and that's good. It should be that way.
So you took the position earlier, at least I think you did, that having 28 or 68 or 168 different laws, national laws, regulating what is within and not within this right to be forgotten would be a good thing. Mm-hmm. But wouldn't Ross say that that's actually even worse from Google's perspective than one universal set of right to be forgotten rules, and because then there will be different determinations of what's in and what's out, depending on which country is accessing is performing the search, or a resident of which country is performing the search. Are you worried about that?
I mean, the compliance cost for Google to figure out 28, I mean, they're figuring this out themselves. The huge problem is that Google is now in charge. This gave Google so much power. And so that is bad, but if the proper procedural mechanisms are put in place, Google doesn't have anything. They can actually automate this process. But wait
a minute. How could they so let's pretend there were 168 different rules involving the right to be forgotten. Presumably, each one will have. I mean, you know how legislation is written or common law decisions are made. It'll have standards and balances and factors and so forth, not so dissimilar from this decision, right?
Right.
How is it that it could be automated?
The proper procedural mechanisms are that Google is just adhering to agency and court orders. That they can automate. They should not have to, nor should they be developing 168 or 1 or 3 rights to be forgotten. But my hope is that there will remain a number of different rights to be forgotten, and that Google will not be put in charge of developing any of them.
And in any event, it sounds like in your idea it wouldn't be part of the tort system where Google would somehow be liable for having allowed a search that they shouldn't.
I mean, they could challenge a court order, certainly. They've done that with defamation claims. And then, again, the jurisprudence develops around that by proper individuals like judges and other lawmakers.
So, Ross, do you also see this decision expanding to other jurisdictions? And how would you deal with, even if it were done through courts or through legislation in a lot of different countries, how would Google handle that?
It's a very valid fear that we have right now is sort of the adoption by other jurisdictions of a similar, right to be forgotten. And in particular concern to us are those countries which are going to use this for purposes other than protecting its citizens' privacy rights. Certainly seen a history around the world of much more authoritarian countries, passing regulations or laws under the auspices of, child safety and similar sort of goals, when actually the goal is to censor information and prohibit individuals' rights to expression and share information. So that's a very, very real concern we have.
Though we have examples, of course, of companies that want to do business in more repressive regimes that already, and I don't know if Google is one of them, accommodate certain requests from governments to not to block access to certain websites or to censor content in certain ways already. This would just be a sort of one of a kind along the same lines, no?
Well, that doesn't take, I don't know, I'm not quite sure. I mean, I think that's true, but that doesn't mean that we should welcome yet another avenue that countries and law, and certain countries can use as a way of stifling free speech and free expression. So that's very much a concern of ours. You're absolutely right that different companies make different decisions about which markets to operate in and which not, and hopefully those decisions are based on things beyond bottom line issues, financial issues. But I was actually before coming back to DC, I was in Asia for 3 years, and I was sent out there at the beginning of 2010 to help us deal with our China issue, which you may recall. And I'm extremely proud of the decision the company made in that situation to actually move our search engine functions out of mainland China in response to the increasing demands of censorship demands of the Chinese government. But it's up, companies make these decisions in different ways, and they sort of balance it out differently.
And Arturo, there's this group of kind of international organization called the Internet Governance Forum that is made up of a number of countries and is sort of designed to try to build more unified standards, if you want to take the positive spin, or the negative spin would be establish world governance of the Internet, I guess. Do you have a sense of where that group is moving and how much impact they will have?
I wasn't in Istanbul a couple of weeks ago, so I don't have the firsthand sense, but I imagine there are a wide range of views being expressed. I'm sure there are some organizations that are very pro-privacy, more European-focused, and applaud this decision. And I'm sure there are others who are concerned about the imbalance, in relation to other fundamental rights, expression and information in particular. I agree with Ross that the governments at the IGF who have embraced this may not all have the most altruistic of motivations. When Russia says it's concerned about the privacy of its citizens, I think it's fair to be a bit concerned about that, especially if you're one of the citizens. But I think that this will continue to be a debate with a lot of different perspectives, and much of it is local. I think what's interesting about the case in the European Union is that with the data protection regulation, there would be a unified agency. You wouldn't have the 28 anymore. It could be that this regulation could sort things out in a productive way if it, if the debate around the decision feeds into it in a productive fashion, right? I mean, one hopes that is the solution.
If there were a unified agency that were actually creating clearer standards.
That's right. I think it would certainly make Google's life a lot easier.
Would that make you happy, Ross?
No, wouldn't make us happy. No, because it makes maybe compliance a little bit easier, but it doesn't change the fact that we think that the right to be forgotten gets the balance wrong. I do want to say just a word about IGF, because there are a number of institutions involved in internet governance, and IGF is one of them. And I'm actually, and Google is a big supporter of the IGF because it's a truly multi-stakeholder approach to addressing these issues, unlike some other fora, which claim to be multi-stakeholder and which are really not. So I didn't want to let the characterization of the IGF as an organization which is, at its worst, trying to effectuate, greater government control over the internet to go unanswered, because that's not our view of it.
Okay. So I can't remember whether I asked you this already, but in your view, is some sort of a privacy right connected to the right to be forgotten ever a legitimate? Let's assume that this decision had not come out. Would it ever be the case that anyone could make such a claim to Google and Google would actually do something? I guess you mentioned child pornography. Somebody mentioned child pornography. Maybe that's one example, but
or when we found when there have been malicious actors publicly releasing social security numbers or financial information, that's another instance where we would take those links down. And when we receive a valid court order, we comply.
All right, so questions from the audience for our panel.
And I did want to mention,
put it on microphone because this is being
web streamed,
broadcast out to the world.
And I also wanted to mention, for those watching on the web stream, you can ask questions if you send an email to events@asil.org. I will get it, and we can relay it to the panel as well. So we'll do that as well.
Great.
This is a really interesting panel. Thank you so much. I actually have two questions. The first one is, with regard to the scope of the holding, is it literally just applying to a link existing on through the Google search engine, or does it apply to other things like the links that people have gone to from their own Google accounts, or what's the content of their Gmail, things like that? Is it just removal of links? The other question is with regard to the question of child pornography. I thought I heard a piece on NPR about someone challenging their inbox being searched and then being turned over to the police for purposes of prosecution, and that was in the process of being appealed, I think, through the federal system. And someone was making a Fourth Amendment argument as to it being an unreasonable search and seizure. So I was wondering if you'd comment on that, Ross.
On the first question, I think our interpretation is that this applies to, as far as we're concerned, it applies to our role, quote, as a data processor, and therefore our linking to web material. It doesn't go deeper than that. And I'm not in a position to comment on the second matter on the case.
Does anyone else want to comment on the?
Well, on the second matter, the Washington Post called me about this, and it's there's a law, and it says Google, not only, if they're aware of it, Google Bing does this. It's a big, it's been they've gotten a lot of public support for this, but when, it's just similar to a hash file run, they use a fingerprint process for matches against child pornography, and it's in the law. If they have actual knowledge of child pornography, they are required to turn that over. So I don't know exactly what they're challenging, but it's one of the rare instances where they have to turn it over to criminal.
Meg is right. I wasn't aware of the appeal that you were talking about, so I wasn't in a position to comment on it.
Okay, so we have a question here. Go ahead. Well, I don't know. Which view? Okay, go ahead.
Just for Meg, before she has to run away, what does a legitimate right to be forgotten look like substantively, following up on your earlier point? I mean, is it when you yourself have uploaded information about yourself that you later regret, such as when a child uploads a photo of themselves in a compromising position and no longer wants that to be linked to their name, when you write a scathing blog post that you no longer agree with 10 years later, and if that perfect right to be forgotten exists, is there a way to push it into law, either at the European level or at the international level, so that countries like Russia and India have better examples to follow?
So I am the least political person on the planet. I don't care about any of this. I just want things to fit within their own cultures. Also, I have a real problem when things are not legally or technically interoperable. And so the right to be forgotten in its current state is just jamming up all kinds of avenues. For the U.S., which is what I have been looking at specifically because it's the hardest place to fit a right to be forgotten, I came up with a few categories that at least people are pretty sympathetic to. Kids being one of them. We already have California's law, and that is very specific. It's just for kids to force removal of what they've uploaded when they have a username and when they have an account. So it's really specific. Most platforms already provide it, but it's still important, out of principle. The other one that I came up with was victims of violent crimes when they're identified. While we do have Florida STAR is in our jurisprudence, I do think that we could argue over time maybe those identifying characteristics could be removed. Also, when people have sex changes, being able to disassociate themselves with their prior sexes when they are taking on a new gender identity actually causes a lot of discrimination problems, and so we might find some footing in some interesting places. But those are the three that I've sort of said, okay, America might be able to pull this off in this area as a starting point. Other places have a really long history of this. Switzerland has a really long history of allowing for criminals to disassociate themselves with, a news agency can't talk about a criminal in relation to their past crimes. That is actually pretty common in most European jurisdictions. The way it's implemented is very different, but the public figures is also not universal. Lots of places don't recognize public figure as an exception. They certainly don't have the heightened standards. And so as far as finding that perfect one, I think it's how do you fit it into the existing jurisprudence, the existing law, and what is it based on? I think it's usually based on this combination of defamation and data protection. Like, you just have to figure out where it sort of fits within those needs, and then talk about some specific scenarios that that culture is really sensitive to as a starting place.
And Ross, would you reject those three areas, since you were pretty strong at thinking that the right to be forgotten is sort of not something that you should think should be mandated by governments again and targeted at Google? Do those three seem unreasonable to you, or?
No, I think the bigger point is that we shouldn't be in the position of making that decision. That should be a part of a discussion and debate that a society has itself, and then, you know, and then enshrined in legislation, and then with the courts as a check on that, on the implementation of that legislation. You know, that's our view. It just shouldn't be, go do this, Google.
I also want to emphasize that, technically speaking, Google does not have to have anything to do with this ever, which is nice for Section 230, which exempts them in the U.S. Robust text, but you can go to the source and you can ask the source who put up the information, which kind of goes to your question about aging information. It's 10 years old. Do you care about this? And, you know, I go through this very long and sort of complicated information lifecycle process, which is what information manager would do. But you can go to these individual sources and add a technical solution there, and Google's system is set up then to automatically not index that page. So Google can actually be left out of it entirely, which is how the U.S. would very much prefer it.
Okay, question here. Do we have any questions from the internet audience yet? Okay, go.
Thanks. My name is Courtney Radge with the Committee to Protect Journalists. I have a couple of questions. First, with respect to journalistic content and, you know, the ability of journalists to do their jobs, I think the point that, you know, somebody may not be a public figure when they request the removal of content, but they become so later, is very important. And it seems to me that some of the initial takedown requests and then put back, and who knows if, you know, continuing, had to do with journalistic content. So where are we on that side of things? And then also, I think that this idea that, you know, every culture can decide where those boundaries lies is problematic when you are in societies or nation states that don't have any sort of democratic process. And it's really concerning to talk about not caring about the context, because I think that opens up a can of worms. And we're already seeing, you know, some cases in the Middle East, for example, and some repressive countries in Asia that are talking about using this as a way to stifle free speech, as has been pointed out. And then my second question specifically for Ross is, you know, or maybe not just for Ross, but, you know, Google is a much bigger resource-rich company, but this ruling applies to all search engines. So how feasible is it for other less well-resourced, smaller search engines to implement this? And would this not be then some sort of economic barrier and actually then contradict Europe's goal of actually reducing the dominance of Google, because perhaps only major companies like Google or Yahoo or, you know, the major national search engines could even comply with this? And I think just the last point, in terms of going to the source to take down the content, I mean, there are pros and cons to that. I think, you know, that's if it's illegal and or illegitimate, that seems to be the right course of action. But in terms of irrelevance, that still, I think, you know, begs to differ, because it could be even worse to remove it completely from the public domain versus just the way that it could be found.
Responses to those points?
I'm going to answer and then pop out, if that's okay. I'm sorry about that. There was a lot of points in there. I don't think anybody on this panel is actually arguing for complete removal. Maybe I'm missing that, but if that makes you feel better about your last point.
Although the implication of what you said at the end when you were talking about the various national legislation is that we could leave Google out of it, and there could be national legislation or court decisions that would go to the source, to the web page itself, presumably.
The technical solution offered is not erasure; it's a robot.txt file, which prevents the crawler from, I mean, ethically, an ethical crawler from indexing it.
Well, and in this case, the original source was a newspaper, and it was exempted from the order because of the journalistic exception in the directive. So journalists are protected within this regime, and that's why, at least in this case, that was not an issue at the
It becomes
source.
increasingly difficult in today's world to determine who is a journalist and who's not.
Right.
Of course, as you know, Arturo. So
Yeah, no, that's a fair point.
Yeah.
But at least in this case, that was the one thing that was clear.
Right.
Yeah, to the authoritarian regime problem, I guess
the concern about having many, many national rights to be forgotten.
Yeah, I mean, I don't think that doing it this way prevents that in any way. I mean, I guess I package that in a bunch of problems. Like, it's an information problem in so many ways. The right to be forgotten would be problematic if it was utilized inappropriately, just like all the other information policies utilized inappropriately. And when we solve the rest of those, we should totally solve the right to be forgotten as a package deal. But there are some interesting technical solutions, even though it can be abused, I guess.
Yeah, and on the legal side, the European Court of Human Rights system, I think, eventually is going to have to weigh in, and I think there will be a bit of a sorting out of standards that apply at a general level. Ross doesn't look happy at that, but it could be positive, and that would help to mitigate this, right, the fragmenting of the different jurisdictions. And it will take into account the court of the European Court's decision, but I don't know that we'll have a fractured system for indefinitely. It will eventually start to sort out at that level with these systems. Yeah.
Right. I mean, in some sense, any new regime or new right or new legal doctrine that is articulated often has a lot of uncertainty in the beginning, and then gaps get filled in over time, either through legislation or through common law judge making and so forth, depending on the type of jurisdiction. And so it may be that at least some of the uncertainty goes away, but it still puts Google in the center of having to interpret whatever body of law is, at least as it's currently set up.
Although this is a pretty exceptionally vague.
Right.
Interesting on the journalism point, the New Zealand court last week in Slater v. Bloomfield actually found that bloggers could be, in New Zealand at least, can be considered journalists, and that blogs therefore are journalistic outlets. Of course, the New Zealand Shield Law also allows judges to remove protection from journalists in specific cases, and they then went on to remove the protection from that particular blogger in that case. But just a recent decision on that.
David Carney, Tech Law Journal. Question for Ross. Could you talk about some of the competition issues? For example, as Google develops a database of decisions on these requests, is it making it available, or will it make it available to other search providers? Are you communicating with other search providers about setting up a unified process? Have you submitted a business review letter to the antitrust division or engaged in similar processes?
Our approach right now is to really take, sort of wholeheartedly our responsibility under the ruling and figure out the best way of moving forward. I'm not aware of, discussions that we're having with other search engine providers of a sort of unified approach. The advisory council that we've set up is really the vehicle for addressing, like I said, the larger issues and the larger implications.
Other questions here or elsewhere? Okay, I think we have gotten to the end of our hour and we've run over a few minutes. So I want to thank all three panelists and thank you all for coming, and I hope you found it to be an interesting and provocative conversation.
Thank you very much for panelists. I did want to mention really quickly, if you're interested in more about ASIL, specifically about membership with the Society, there's information downstairs on the table before you leave you can take. But join me in thanking our panelists for a wonderful discussion.
Oh my goodness. Go to the next one. Hey, David.